We are going to now cover a section in HR that's very vital to the organization, and it's called Employee Rights and Discipline. Our objectives here, we want to look at the concept of employee rights and employer responsibilities. We want to take a look at the concept of at-will hiring, wrongful discharge, implied contract, and the topic of constructive discharge. We're going to learn the meaning of discipline and why it's necessary that it's conducted properly. We're going to look at some of the different types of alternative dispute resolution methods, and we're going to examine the concept and role of ethics. So, employee rights, various federal and state laws and protection of employment status guarantees fair treatment of all employees by employers. Employer privacy rights are those federal and state courts generally view the privacy rights of employees as minimal. In other words, employees don't really have a lot of privacy rights. There is a lack of comprehension and consistent body of privacy protection, whether from laws or from court decisions. It's kind of a gray area, and my key statement to you is document everything that you do and keep a record of it in the employee's file. Negligence is a failure to use a reasonable amount of care when such failure results in the injury to another person. Negligent hiring is a legal doctrine that places liability or duty of care on the employer for actions of its employees during the course and scope of their employment. A psychological contract is the expectation of a fair exchange of employment obligations between an employee and their employer. The employment at will principle is the right of an employer to terminate an employee without giving him a reason, and also the right of an employee to quit their job when he or she chooses. A wrongful discharge is a discharge or termination of an employee that is illegal. An implied contract is a wrongful discharge contrary to an employer's oral or written promise of continued employment. In an employed covenant, wrongful discharge for lack of fair dealing on part of the employer. Discharges that violate public policy are all listed here, or not all of them, but some of them. And an employer may not terminate an employee for a lot of different reasons. For instance, refusing to commit perjury in court on behalf of the employer, or whistleblowing or reporting illegal conduct by the employer. You can't do that. We'll talk about that again soon here with retaliation. I'll leave this for a moment for you to read, and again, you may also pause it at any time. Whistleblowing, we were just talking about that. It's complaints to governmental agencies by employees about their employer's illegal or immoral acts or even unethical acts or illegal practices. As you can see here in the cartoon, it says you did the right thing, whistleblower, so naturally we have to fire you. Goodbye. No, that can't happen, folks. An implied contract is when a promise by the employer suggests some form of job security to the employee. Employed contractual rights can be based on either oral or written statements made during the pre-employment process or subsequent to actual hiring. An explicit contract is formal written agreement that grant to employees and employers some agreed upon employee benefits and privileges. Constructive discharge is an employee voluntarily terminates his or her employment because of what they feel is harsh, unreasonable employment conditions placed on them by the employer. Discharge is a result of retaliation. We were just talking about that with whistleblowing. Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, the American with Disabilities Act, and other employment laws prohibit employers from retaliating against any employee when they're exercising their rights under these statutes. The Workers' Adjustment, Retraining, and Notification Act, or WARN, of 1989 requires organizations with more than 100 employees to give employees and their community 60-day notice of any closure or layoff affecting 50 or more full-time employees. Terminated employees must be notified individually in writing. The Act allows several exemptions, including unforeseeable circumstances. An example: your facility catches on fire and burns down. Now you have to lay everybody off. Well, obviously you couldn't give 60 days notice, so that's one of the unforeseeable circumstances. U.S. companies can legally test workers for drugs. There are some circumstances, and most are regulated by the individual states. The employees must submit to a drug test when reasonable suspicion for a drug test exists, and the employer's testing procedure are also reasonable, or if the job they're going to be performing is specified as it has to be a drug-free or free of impairment. Impairment testing, also called fitness for duty or performance-based testing, measures whether an employee is alert enough to work. Camera surveillance. Many companies today monitor their employees. Some claim it's to protect employees, and some do it for company interest. Few federal laws protect workers from being watched. Now, personally, I don't care if they film everything in the workplace, as long as they're not filming me in the restroom. Other than that, I'm doing my job. I don't have to worry about me doing anything wrong. A lot of times it's done for safety purposes. How do you feel about this? How do you feel about your business having cameras up and taping everything you do? Phone conversations and text communications. Employers have the right to monitor calls and text messages sent from their devices, provided they do so for business reasons, and the employees have to be notified that their communications will be monitored. Email, internet, and computer use. Yes, employers can monitor what you do online, and they may terminate or discipline you based on that information. Now think about the fairness. You're at work. You're supposed to be doing company work with company equipment. Surfing the web, looking at Amazon, sending emails and social media texts are not part of your job, and therefore, in most cases, you can be terminated for it. How do you feel about that? I think personally, if you're there doing the work, you shouldn't be doing social media. You shouldn't be surfing the web. You're there to do a job. The search policy should be clearly defined in an employee handbook. The handbook should explain searches will not be conducted without a good reason for it. When possible, searches should be conducted in private and should attempt to obtain the employee's permission prior to the search. The search should be conducted in a humane and discreet manner to avoid infliction or emotional distress, and to not have embarrassment for the employee in front of other fellow workers. The penalty for refusing to consent to a search should also be specified. For instance, if you refuse to allow a search, then we're going to have to terminate you today. Personnel files. Employees generally have the right to know of the existence of their personnel file. They have the right to inspect their personnel file. And believe it or not, you have the right to correct inaccurate information in that file. However, employers can restrict access to information that could violate the privacy of others, limit the employee to copies of documents that he or she has signed, or require that HR personnel or a supervisor be present while the employee views those documents. Off-duty conduct and speech. In some places, it's a big issue. Organizations that discipline employees for off-duty misconduct must establish a clear relationship between the misconduct and the effect it has on other employees or the organization. Off-duty employee search. Some organizations have social networking and blogging policies that restrict employees from making disparaging remarks about the firm, about their supervisors, or otherwise trying to cast the organization in a bad light. Workplace romances. Should dating be allowed within the organization? Should supervisor and subordinate relationships be allowed? I think they're of particular concern. Number one, to other employees, they're going to feel like you're showing favoritism to your romantic partner. And while everything is going good and the relationship is great, everything is lovey dovey. But what happens when they break up? Are there ill feelings, retaliation? It can cause problems, and I suggest you don't allow it. What about body art, grooming, and attire when you have people working for you dealing with the public? Would you hire the following people? Now remember, your employees, most of them, have some contact with your customer or the public. So if you're working in a mall and you're hiring a salesperson, you're probably not going to pick someone like this. I don't have anything against these people. They're expressing themselves, and I think that's wonderful. But do you want these people with these kind of facial and body art items facing your customers? And by the way, this answers my one question. This, to me, is just ridiculous. That is way too early. But hey, that's just my opinion. I'm old-fashioned. All right, so disciplinary policies and procedures. You have attendance problems, dishonesty and related problems, theft and so forth, work performance problems, and on-the-job behavior problems like bullying, intoxicated at work, sleeping on the job, or failing to use safety devices. I'm going to leave this poster up for a moment for you to review, and again, you can pause it at any time to read further. Result of inaction. Reasons given by supervisors for their failure to impose any kind of a disciplinary penalty. Number one, the supervisor failed to document earlier actions, so there's no record existing on which to base any subsequent disciplinary action. So if you gave somebody an oral warning, verbal warning, as they call it, and you didn't document that, the next time you can write them up, but you can't do anything about it because you didn't have anything before that. So you're going to need 2 or 3 write-ups now. That's why it's important you document. Supervisors believe they would receive little or no support from their upper management for the disciplinary action. I recall once in my early days of management, I was going to let an employee go, and upper management stepped in and said, no, we like this person and they're going to stay. So that undermines the supervisor. The supervisor was uncertain of the facts underlying the situation that might require disciplinary action. So if you're not sure, you really can't do much about it. But again, you can still document it. Failure by the supervisor to discipline employees in the past for certain infraction cause a supervisor to have to forego doing it this time so that you're consistent. You can't let one person go and then write somebody else up for that offense. The key is be consistent, fair, and firm with everyone. And number one big rule of failure, the supervisor wanted to be seen as a likable guy. Big mistake. All right, setting some organizational rules. The rules must be reasonable and relate to the safe and efficient operation of the organization. The rules and the consequences for breaking them should be written and widely, clearly disseminated to all employees. Neglecting to communicate the rules is a major reason why a lot of times these things wind up in court and the actions are reversed. Rules should be clearly explained. Employees are more likely to accept a rule if they understand the reason behind it. Employees should sign a document stating that they have read and understood the organizational rules. Generally, there's an employee handbook, and in there is a page where you sign it saying, I have read and understand, and you return to HR, who in turn puts it in your employee file. Rules should be reviewed periodically because things change, right? Perhaps annually, especially those rules that are critical to work success. And again, investigating a disciplinary problem, a lot of questions to ask, a lot of steps to take. I'm going to leave this up there for you for a few minutes to read. And again, please feel free to pause this presentation so you can read it more in depth. Okay, let's move on. Documenting the misconduct, very important. You need to write down the date, the time, and location of the incident. What was the negative performance or behavior that was exhibited? Define that problem. What are the consequences of that action or behavior on the employee's overall work performance and or the operation of the employee's work unit? Prior discussions with the employee about the problem. If you've had discussions before, document it. Disciplinary action is to be taken and what specific improvement is expected. Within the next 2 weeks, I don't want to see you come in late again. Consequences if the improvement is not made with a follow-up date. In the 2 weeks, if you are tardy once again, we're going to go the next step. You're going to get some time off without pay. And your final step, if you do that repeat, is we're going to be letting you go. The employee's reaction to the supervisor's attempt to change that behavior should be documented. If they're insubordinate or rude or disagree with you or whatever, make sure you document that also. And make sure you list in the names of any witnesses to the incident. That's important if you have any. When you have a problem, you should do an investigative interview. And the conduct of that interview is concentrate on how the offense violated the performance and the behavior standards of the job. Avoid getting into any personalities or areas unrelated to job performance. It's strictly about the job. And the employee has to be given a full opportunity to explain their side of the story. Discipline basically is a tool used to correct and mold the practices of employees to help them perform better so they conform to acceptable standards. See, discipline is often a negative word, but it really isn't. And if you read this definition, you understand what I mean. Discipline sounds like treatment that punishes. You want orderly behavior in your organizational setting, and that discipline is necessary. You could have training that molds and strengthens desirable conduct or corrects the undesirable conduct and helps develop some self-control. Progressive discipline is the application of corrective measures by increasing degrees. All right, we're going to fix this. Step 1, we're going to do this. When you've got that right, we're going to go to step 2 and step 3 and so on. When applying corrective measures by increasing degrees, always be sure the employees know where they stand regarding the offense, know what improvement is expected of them and by when, and understand what happens if the next improvement is not made. What's the next step if they don't get better? Positive or non-punitive discipline is one that focuses on the early correction of employee misconduct with the employee taking total responsibility for correcting the problem. Now, when you're having one of these sessions, I'm going to recommend again you use the sandwich technique. Start with something positive. Insert in what you feel is bad and you want corrected, and then finish on a positive note. For instance, Jerry, you are a really good worker. You produce a lot of great quality product, and your employees respect you. However, you're coming in 5 to 10 minutes late every day is setting a bad example for others, and they're going to think it's okay for them to do. You need to be here on time, okay? That's important. But, again, we love your work. You do great quality work, and we just need you to work on this problem. That is the sandwich technique, people. When you do the discipline model, refer to past feedback. Ask why that undesired behavior was used. Why did they do what they did? give out the discipline that corrects it, get a commitment from the employee to change, and then develop a plan. All right, we're going to review this again in 2 weeks, see where we stand. So you summarize it all and state the follow-up. And make sure you do the follow-up. All right, when discharging employees, first should be an oral reminder, as we call it. Second is a written reminder. And then the third time you make a decision, you either give them time off without pay, or you terminate them, or whatever you decide to do. Here's the whole process. I'll leave this chart for you so that you can review it for a couple of moments. All right, conducting a discharge meeting. You bring in the employee to let them know you're letting them go. So commit to the point within the first 2 or 3 minutes and list in a logical order the reasons for those termination. Be straightforward, firm, tactful, remain resolute in your decision. Don't back off. Once you've made that decision, stick with it. Make the discussion private, businesslike, and fairly brief, usually within a closed office, HR office door. Don't mix the good with the bad. Don't try sugarcoating the problem. You'll send a mixed message to the employee. They won't understand then. Avoid making accusations against the employee or putting in any personal feelings into the discussion. Avoid bringing up any personality differences between you and that person. Provide any information concerning any severance pay and the status of their benefits, insurance, or coverage, etc. And finally, explain how future employment inquiries will be handled. So, can I get a reference from us? Yes or no, da-da-da. Due process. Procedures that constitute fair treatment, such as an employee to tell his or her story about the alleged infraction and defend himself. An alternative dispute resolution is a term applied to different employee complaints dispute resolution methods that don't involve going to court. Step review system, reviewing employee complaints and disputes by successfully higher levels of management. Peer review is an interesting one. It's a group composed of an equal number of employee representatives and management appointees, and almost like a jury, since the members will weigh the evidence, consider arguments, and after deliberation, vote independently to render a final decision. This is probably one of the best fair practices that you could have in a business. Involve the other employees. That way it's like a jury. Open door policy. This is when you settle grievances that identify various levels of management above the immediate supervisor for employee contact. Ombudsman is a dedicated individual from whom employees may seek counsel for the resolution of their complaint, and they are an advocate for a fair process, not an advocate on behalf of the individual or the employer. When handling employee complaints, remember a complaint is an expression of dissatisfaction with the situation, often coupled with their request for change. Its ability to handle the complaint properly requires you have strong leadership skills, you properly listen, and you have patience. Here's how you handle it. You listen to the complaint, you paraphrase it back. Okay, as I understand, you feel like Mark is constantly scratching your work, and that's making your work look bad. Ask the complainer to recommend a solution. Okay, so what do you think we should do to fix this? Schedule time to get all the facts and make a decision. Then get back with the employee after you develop a plan for addressing the complaint. Put the plan into effect and follow up. Make sure you follow up. Otherwise, the employee is going to feel like they didn't care, they didn't listen to me. Mediation. The use of an impartial, neutral person to reach a compromise decision in an employment dispute. A mediator is that third-party person who meets with one party and then the other in order to suggest compromise solutions or to recommend any concessions from each side that could lead to a mutual agreement. The process is basically you bring the parties together, help them resolve conflict by coaching them as how they follow the steps in the model. That person has to remain neutral, focus on how conflict is affecting work, address behavior, not personalities, encourage parties to clarify their statements and their responses, and then follow up to make sure parties carry out the actions that they agreed upon in step 4. Arbitration is the use of an impartial, neutral party as decision maker to help resolve an employment labor dispute by imposing a binding final decision on all parties involved in the dispute. This arbitrator is a third person neutral who resolves a labor dispute by issuing a final decision in the disagreement. Ethics, pretty much a set of standards and conduct for moral judgments that help us determine right and wrong behavior. It helps give cultural guideline to help decide between proper and improper conduct. It's also a set of written standards of conduct or ethical values governing relations with employees and the public. It also provides a basis for the organization and individual managers to evaluate their plans and actions. There we have covered a very important topic, and I hope that you'll take time to look at the next section on positive discipline practices. Thank you and have a wonderful day.